Floyd, Zadkovich, International Commercial Lawyers.
So welcome to Floyd Zadkovich's presentation series. I'm delighted to be here today. I'm going to talk to you about a very interesting topic. Well, I think it's very interesting anyway. It's about a freight forwarding contract. Also has some relevance for other carriage contracts, and we're dealing with an exception to an exception. So for lawyers, it's a fun thing to try and explain an exception to an exception to clients and to our audience, but I'll endeavour to do so in this presentation. And we're really focusing on the obligation to pay freight and when and in what instances you are able to deduct for your claim and set off damages that you may have against the obligation to pay freight. Bit of a spoiler alert. It's very, very difficult to do that, and the obligation to pay freight is pretty much paramount. And note that I'm using the word freight here, so I'm talking about freight under different types of carriage contracts. I'm not using the word hire, which we know is the term that's used for payment in a time charter party. That's a different scenario. So we're really focusing in on the obligation to pay freight. The landmark decision in this area is the case of the Aries in 1977, and it really traversed through 160 years of authority, and it established the rule that you cannot set off any damages claims against the obligation to pay freight. So if you have to pay freight, you have to pay freight. And that sounds somewhat crude, but the principle here is that even if you suffer significant damage, so let's say you're the owner of the cargo and there's some type of carrier fault involved that has caused you a substantial cargo loss. Those damages that you have, you cannot refuse to pay freight on the basis that you have a claim to bring. You have to pay freight and then you bring your damages claims thereafter. In this case, the case of the Aries also established that this principle applies to carriage contracts. And from there have been extensions to this rule which have extended the obligation to pay freight without deduction, without set-off, to carriage by air and carriage by rail and other types of carriage. But importantly, the rule is restricted to the carriage context. There are obviously limits to this rule. Number one, parties they can say otherwise in their contracts. Number two, it only applies to freight. It doesn't necessarily apply to hire in a time charter context, as I mentioned earlier. That can be governed by the contract, and it may have that type of obligation in it, but as a matter of the common law, we are talking about the freight context here. And thirdly, the other limit is, as I mentioned, that this only applies to carriage contracts. And that's important for the case that we're looking at today, the Global Link and DHL case, because it deals with a freight forwarding contract. And the court was asked in this case to look at can this obligation to pay freight and this rule, can it extend to a freight forwarding contract? And the court basically held, no, it can't. A freight forwarding contract, by its nature, is a contract to perform services rather than carriage. Carriage may be an element of that contract, but fundamentally it is a contract for services. And for that reason, this rule about the absolute obligation to pay freight doesn't apply to a services contract. It doesn't apply to a freight forwarding contract per se. Now, what is interesting is and where we get into an exception is that, as you can appreciate, a freight forwarding contract has an element that relates to freight. And in particular, the freight forwarder may pay freight to the ultimate carrier. Now, where the freight forwarder has paid that amount of freight, so that component, to the carrier, the freight forwarder can use that component as a shield, and that component does fall within the rule of absolute obligation to pay freight without set-off or deduction. So if the counterparty has a damages claim to bring against the freight forwarder, they can set off, subject to what the contract says, of course, but they can, in principle, set off against any payments that they have to pay for the services of the freight forwarding contract. But the freight forwarder can say, well, no, you can't deduct in relation to the component of freight that, as freight forwarder, I have paid to the carrier. And I think that's a really interesting gloss here, where you've got almost an exception to an exception, and looking at a freight forwarding contract and saying, well, no, in principle, in general, it's not a carriage contract, but there's an element of it where the freight forwarder is arranging carriage, and that arranging carriage, that element of the contract, can be pulled within the principle of that there's an absolute obligation to pay freight without set-off or deduction. So, a short presentation today. I thought you might be interested in it. I hope you found this this content and also the delivery method interesting and relevant to you and your business. If you have any questions, please do let us know, and we'd be very grateful if you shared this video with your network. And keep in touch. All the best.